The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to rise, draw an eye, and give their attention to the court now sitting.
Thank you. Please be seated. Good morning. Welcome to the Supreme Court of Kansas. We have carefully read counsel's briefs on the cases for this morning's docket, and we look forward to your further enlightening comments this morning. Before we proceed with the reading of the docket, I did want to acknowledge some guests. I believe we have a group of students from Brown Mackey and Salina. Is that correct? Okay, and we'll dispense with individual introductions, but what class is this, sir? What class are they representing?
American Judicial System, Criminal Justice Major.
Very good. Welcome, Brown Mackey. Any other groups to be identified? Anybody care not to be identified? Very well. We'll proceed with the reading of the docket. Ms. Green, as clerk of the court, will you do the honors? Thank you, Ms. Green. Before we proceed with calling the first case, I will announce that I am recused on the last case this morning, and sitting in my place will be the Honorable David Bruns, a judge on the Kansas Court of Appeals. Judge Bruns is very familiar with the case. He's read all of the briefs and documents associated with them. He'll participate in the case conference this morning and the ultimate resolution of that case. That said, we'll proceed with the first case on this morning's docket. That is case number 105785 in the matter of the appeals of various applicants from a decision of the Division of Property Valuation of the State of Kansas for tax year 2009. In the matter of the application of various applicants for exemption from property taxation in the State of Kansas. Counsel, you may proceed.
Thank you, Your Honor. May it please the Court. Robert Kirkendall on behalf of the taxpayer appellants. I would request to be allowed to reserve 3 minutes for rebuttal.
3 minutes is granted.
This case presents the question of whether the out-of-state title holders to natural gas, which gas may or may not be in Kansas, held in a pipeline and underground storage, may be subject to Kansas property tax. We submit that the answer to this question is easily arrived at by a straightforward application of a prior holding of this court, and that holding was in Re Central Illinois Public Service Company. In that case, the court held that the plain meaning of the merchants and manufacturers inventory exemption contained in the Kansas Constitution reaches the very parties that are again before this court. These entities are not public utilities within the meaning of the Kansas Constitution, and therefore are constitutionally entitled to the exemption for merchants and manufacturers inventory.
Counsel, I wonder if we could, before you get into your argument, I want to get straight who the parties are on your side of the ledger. And the reason I say that is because as I go through this, when I look at your brief, you seem to divide the group up into three. The property valuation folks seem to divide them up into 4 groups, and then the Court of Tax Appeals went back to 3, and I just want to see if we can, is it fair if we divide up the total universe of taxpayers here into number 1, out-of-state natural gas marketing companies, number 2, out-of-state municipalities, and number 3, local distribution companies certified as public utilities in other states, which would be the grouping that the Court of Tax Appeals use?
I believe that the division is not particularly clear, but that is the typical division that I think applies.
Are there any subsets of any other of those 3 groups?
You might have some out-of-state investor-owned utilities that are operating brokerage or marketing facilities, so they might be, instead of out-of-state utilities, more in the marketer and broker category, but the lines are not particularly crystal clear within that group.
Okay, so let me follow up then, if I may. If that's the case, do we have, and we think it's important as we get into this, that it makes a difference whether you're a marketer or an out-of-state utility, for example. Do we have enough facts to be able to differentiate between each of the taxpayers who are on your lists at the bottom, in your opinion?
In the record, there are individual stipulations of fact between the entity and the Department of Revenue that does state what or what capacity or how those entities fit in here. And I believe within those stipulations, you could place them into one or more of the categories.
If we think that the distinctions make a difference when we get into the analysis, and it depends on which way the legal issues cut, whether it does or doesn't, I'll give you that. But if we get there, would it be your opinion that it would be better for us to make those distinctions here or send it back to the Court of Tax Appeals to divide the taxpayer groups up into the respective, based on the respective criteria, if that makes sense?
If you are drawing a line that has not been drawn before, is not existent in the cases, I believe it would probably be more appropriate to ship the entire matter back down to the Court of Tax Appeals for them to take a first crack at dividing that line. Again, if there is a new line here to be drawn, I'm not sure whether the facts have been fully developed to clearly place the people in these various categories. So I would suggest if that is important, that a remand for that purpose would be appropriate.
Okay, thank you.
But it is our position that it doesn't matter whether the entity is a broker, a marketer, an out-of-state utility, or a municipality. These entities were before the court before on at least one occasion and probably two occasions, and this court has held that they are constitutionally entitled to the merchants and manufacturers exemption. I want to talk about the Central Illinois decision. Then I do want to touch on some of the constitutional concerns that we think apply if the Kansas Constitution is construed to reach these people. In 1992, this is after the court had once ruled that gas held for resale by a public utility qualified as merchants and manufacturers inventory, the inventory exemption in the Kansas Constitution was amended and narrowed by excluding the inventory held by public utilities. Voters adopted the exception to the inventory exemption for public utilities in 1992, but in that year, coincidentally, FERC Order 636 was also adopted, making it illegal for the pipelines to act as gas merchants, and so they could not then own gas that was stored on their system. These two events set the stage for the Central Illinois public service case. In Central Illinois, various out-of-state entities, basically the same type of group or the same group that are appearing before you now, claimed that natural gas was stored on their behalf in Kansas, was exempt because they were not public utilities within the meaning of the Kansas Constitution. This court looked at the statutory definition of public utilities that existed then. That was the same as it was when the Kansas Constitutional Amendment was adopted in 1992. And it required that for a Kansas natural gas company to be a public utility, it must own and operate pipeline facilities in the state. The taxpayers in that case, and the taxpayers before you now, do not own pipeline. All they had was some type of title interest to the gas on the pipeline. And this court in Central Illinois held that these taxpayers did not meet the statutory requirements for being a public utility. But in that case, Meade County argued something further. They argued that even if The taxpayers didn't meet the statutory definition. Didn't matter. The Constitution reached that gas. The property was still covered by the constitutional provision that provided for taxing public utility inventories. So this argument, basically the same argument that is before you now, was heard in Central Illinois Public Service, and this court rejected that argument. The court held that the only way to look to determine what the voters in Kansas meant when they adopted the 1992 amendment was to look at the statutes in existence at the time the constitutional amendment was adopted. So the court rejected Meade County's argument that the term public utilities, found in Article 11 of the Kansas Constitution, should be construed in a manner that would permit the inclusion of these people. From this case, we know the meaning of the term public utilities as found in the Constitution. As this court held, that term means what it was defined to mean in the Kansas taxation statutes when the constitutional amendment was passed. And we know from these holdings that that definition does not include these taxpayers. What then is the effect of the 2009 statutory amendment that was changed so as to reach these parties? We would submit that this was a gesture that was completely ineffective. The legislature cannot change the reach of the Constitution. As this court recognized in the Central Illinois case, the constitutional amendment determined the size of the mesh in the net, and the voters approved the mesh size. That mesh size is fixed in the Constitution. By seeking to change the class who are considered to be public utilities, the legislature really is trying to impermissibly adjust the mesh size. But as this court held, that transcends the limitations that Kansas voters imposed by the adoption of the 1992 amendments. Of course, it is our position that there are serious federal due process and Commerce Clause questions that must be confronted if the Kansas Constitution were to be changed or were to be construed to permit these taxpayers to be taxed. The limits of due process and the first requirement of the complete auto test under the Commerce Clause require that taxpayers must have a nexus with the taxing state. They must do something to avail themselves of the benefits and protections of the state in order to be subject to the jurisdiction of that state. And the limits on the Kansas's jurisdiction apply to being hailed into court to respond for some tort, as well as the state's taxing power.
Why isn't it enough that the taxpayers entered into contracts with the pipeline companies to store their gas with the pipeline company, knowing that the pipelines have storage facilities in Kansas? And and then the allocation formula that you haven't challenged takes that into effect, or takes that into consideration, much like the argument that Oklahoma used.
Well, Your Honor, we think that is stretching things too far. The fact that you have got a relationship with a common carrier, such as the pipeline companies, it's never been deemed a sufficient nexus with the state in order to justify the taxation power. In this regard, we believe that the Bell Hess case that held that there is a bright line rule that says if your only connection with the state is through a common carrier, you are not constitutionally present in that state in order to justify taxation. It's the same argument with respect to the common carriers. Now, take, for instance, some of the pipeline entities. We have a number of entities that are located up in Minnesota. They deliver and receive gas on the northern pipeline system. Their delivery point is up in Ogden, Iowa, which is downstream of Kansas, the way the pipeline flows. And their receipt point out of that is in Minnesota. So they deliver gas into the pipeline in a place outside the state, receive it back from the pipeline in a place further outside the state, and yet every year they are getting a tax bill from Kansas. They have done nothing at all to bring themselves within the jurisdiction other than having a contract with a third party that has some facilities in Kansas. And that, we believe, does not justify either the due process requirement that you must purposely do something to avail yourselves of the benefits of the state, or the first prong of the complete auto test, which requires more of a nexus.
Why doesn't the allocation formula take that into account? Because we still are looking at gas that is being stored in Kansas on the assessment date, which I think is January 1.
There certainly is gas in Kansas that is being stored. The problem is you are making this assumption, this factual leap to saying that it is our taxpayers' gas. You cannot, there are 4 requirements of the complete auto test. One is the nexus requirement. Another one is the allocation requirement. What you're doing is you're wrapping those 2 up and saying they're one requirement, that you can somehow apply the nexus by doing an allocation. And that really confuses and twists these 2 requirements up and essentially makes the nexus requirement completely meaningless. Again, the nexus requirement requires that you do something to subject yourselves to jurisdiction there. And simply entering into a contract wholly performed outside of Kansas doesn't get you there under the Constitution.
Well, but when you enter that contract, you know that there's a possibility, at least, that a portion of the gas that you hold title to is going to be stored in Kansas.
Well, again, nobody knows where the gas you deliver is actually going to be stored. What you're talking about is at this stage you do know that some allocation is going to be made and you might receive a tax bill. But the requirement of the purposely availment requirement and those others require something more than notice. The court cases say that something more than mere notice is required. You must do something to purposely avail yourself of this. And keep in mind that all the time that the gas is under control of the pipelines when it is in storage, it is under control of those pipelines, and the risk of loss is on those pipelines. So to that extent, if the gas suddenly disappeared, these out-of-state entities that are entitled to recover their gas from their point downstream would still be entitled to recover gas from the pipeline company. In that regard, they receive no benefit at all from the actions of the pipeline company in making the decision to store their gas in Kansas versus any place else. That all is operational. I will reserve the balance of my time.
Do we have any questions of counsel? Thank you, counsel.
May it please the court again, I'm William Waters for the Director of Property Valuation. This case raises the fundamental question of whether the legislature, as empowered by the people, set the tax policy of the state, or whether the FERC inadvertently, through its orders, sets the tax policy of the state. This is a property tax. This is a tax on property. The properties, stored gas, inventories held for resale. What's the mischief that the legislature is trying to correct? FERC 636, what did it do? It changed who could own the gas. It did not set out to upset the state's tax policy. So the question really becomes, does the legislature have the power then to adjust its statutes in response to that federal regulatory change? And during trial at CODA, I asked the taxpayers expert, Mr. Wine, is FERC 636 something that the legislature is empowered to react to? And his answer was yes. So what did the legislature do? It protected the historical classification of stored gas. Stored gas has always been in the public utility subclass. Stored gas was in the public utility class in 1992 when the people last amended Article 11, Section 1 of the Kansas Constitution. It has always been in that subclass. This act was remedial. It protected the historical subclass of the property. It maintains the status quo. It does not upset the status quo. The taxpayers want to turn your attention to the attributes of a public utility. And again, I questioned Mr. Wine on cross-examination at CODA. I handed him a Webster's dictionary. The copyright, I believe, was 1984. And I asked him if the Webster's dictionary definition of a public utility was a pretty good one, and he conceded that it was a simplistic one, but was nonetheless the definition. And it's a three-part test: private enterprise, essential commodity, subject to regulation. All these entities are private enterprises. Even the non-resident municipalities are private enterprises. When they leave their state and leave behind the elements of sovereignty and come into the state to do business.
Counsel, isn't in that dictionary definition that you used, if I recall, also a qualifier that you have to be selling the commodity to the public?
I don't actually recall
It is.
the phrase.
It is.
All right.
Let's just
Well,
operate that way
all right.
for a second. Are there any of these taxpayers who don't sell the natural gas commodity to the public?
I believe they all do.
So if
I
we
believe
were
they
to
all-
add to the public to your definition, you still think you're okay with all of these taxpayers?
Yes, I think this definition very
Even the marketers and the brokers, how would you get
absolutely.
How would that work?
The marketers buy the gas and then they resell it to, say, the local distribution companies, which in turn distribute it to the public. All the gas gets to the public. For example, if
It'd be indirect. It wouldn't be a direct.
yes, but we don't tax entities that store gas and use it in their own manufacturing process, for example. We only tax inventories that are held for resale, purchased, stored, and held for resale. If it's the last time we were here, I was asked what if a farmer stored gas? Well, if the farmer stores gas and sells it to the public, then yes, they fall within the purview of the definition. But if the farmer stores the gas and uses it on his or her irrigation system, then obviously we're not going to tax them. It's not held for resale. So I think, yes, it's resale to the public, and albeit perhaps in some instances indirectly. But we certainly don't tax any gas that's used by an entity that stores it for his or her own use.
Are you okay with the breakdown of the taxpayer group the way CODA did it as opposed to the way you put it in your brief? Because you added a fourth category. You broke out the out-of-state municipalities as a subgroup from what CODA did, and I'm just trying to figure out if that's meaningful or if that just happened to be the way it wrote when you were putting words
Well,
in
it arose because the taxpayer raised different legal arguments with regard to the taxation of non-Kansas municipalities. And so, no, I don't have a real problem with CODA's. I'm asking you to sustain CODA's order. I don't have a problem with that, but I do need to address, I believe, whether or not this court needs to overrule a 1911 case, the Holcomb case, which I believe a fair reading of the appellant's brief would require you to do.
Well, I mean, I
you get
think
that.
the answer to my question then is that maybe we should keep the fourth group, the out-of-state municipalities, so that we can more cleanly address
Yes, I
the
think
secondary issue.
Yes, Justice Files. I think that's correct, because there is a separate, distinct legal argument with regard to whether or not they're taxable. Okay, I want to go now to the complete auto test, the four-part test, which is the modern test for determining whether there's a Commerce Clause violation. I want to go right to nexus. Kansas only taxes the gas that's physically present in this state on January 1. There is no allocation of the gas, period. We tax what is here on January 1 at the stroke of midnight. Now, allocation is a test. That's the second test. We allocate ownership. Actually, we allocate ownership only for 2 of the storage facilities, Northern Natural and Colorado Interstate. Panhandle Eastern and Southern Star do the allocation themselves, but we all use the same formula, and it's the FERC prescribed formula. And again, at the trial at CODA, I asked one of the taxpayers' experts, if it has to be allocated, can you think of a better allocation formula? He couldn't come up with any. He said, and that was Mr. Miller, he said, well, if it has to be done, I can't think of a better way to do it. We allocate ownership of a commingled product. This is fungible. The gas is fungible. And we have the KCC in this, or the Uniform Commercial Code in this state. And we have a definition of what happens when fungible products are commingled. We have basically tenants in common here. They own a piece of every molecule. I mean, they play this hide the molecule game, but in fact, they own a piece of every single molecule. We allocate ownership. We do not allocate the gas. The third test is discrimination. All the gas we tax is valued at fair market value and assessed at 33%. We don't distinguish between non-resident utilities, resident utilities. They have stored gas, inventories stored for resale, gets valued the same, gets assessed the same. As to the fair relationship test, the taxpayers like to say, oh, we would get indemnified for the gas. Well, I think that's a little short-sighted. I mean, you can imagine a massive explosion which might make it impossible for a period of time for these companies to indemnify the taxpayers. That might not be too meaningful to people in Detroit if the weather is 5 below zero. One of their witnesses again testified, well, we had emergency responders out there one time. And then I think in my brief I drew your attention to what happened in Hutchinson when a storage field blew up and 2 people died. I would submit that the fair relationship test is met. There is competition for this storage. That in itself is a service that the state offers these entities. There's competition, and there's testimony to that effect. There's a limited amount of storage, and we have a lot of it here in Kansas. As to due process, Hellerstein and the case law, I think, indicates that it's primarily in this context a nexus test, and if you meet the nexus test under Commerce Clause, then you meet it under due process. And I submit there is no nexus problem because the gas is here January 1, and that's all we value. Now I want to move to, I had a cold for about a month, so sorry. I want to move to the municipality argument. Taxpayers say that to tax the property of the non-resident municipalities violates the Commerce Clause and violates equal protection. They say, but first they make a candid admission. Their admission is these non-resident municipalities don't compete with the Kansas municipalities. No competition. Well, in my view, from what I read, that destroys their Commerce Clause argument. There has to be competition to get a Commerce Clause argument in the first instance. And they candidly admit they don't compete. And the reason they make that assertion is that they're trying to distinguish the Kentucky versus Davis case from the United States Supreme Court that I used and I believe sustains this court's 1911 decision in the Holcomb case. Because the Supreme Court in Kentucky v. Davis said, well, when the state and its political subdivisions go into the marketplace, they're really not subject to the restraints of the First Amendment. Kansas municipalities are market participants. The court actually said, well, there's 2 ways the state and the subdivision goes into the marketplace, either as a regulator or as a market participant. The Kansas municipalities are market participants. They may not be competing with the non-residents, or at least that concession is made, but they're buying gas. They're contracting for the storage of that gas. They're contracting for the delivery of that gas, and they're selling it to the residents of their municipalities. They're market participants. So Kentucky v. Davis is applicable here, and it destroys their equal protection argument. This court in 1911 got it right. A Missouri municipality doing business in Kansas is not entitled to an exemption under our Constitution. This very same article, Article 11, Section 1, Subsection B, exempts the property of Kansas municipalities, or municipalities. And this court has held in 1911, 101 years ago, that doesn't apply to non-resident municipalities. It upheld that distinction. And we have a statutory exemption. The court addressed that in 1911 as well. It's 79201A, second. So essentially, and I know you've read the briefs and you understand Kentucky v. Davis, but what Kentucky does is it exempts the interest of bonds earned from the Kentucky income tax earned on those municipal bonds, and it taxes the interest earned on bonds, say, acquired in Tennessee or Virginia or someplace. And the Supreme Court said that's okay because the state and its political subdivisions, when it goes into the marketplace, is not subject to the same restraints that would occur if the state attempted to create some favoritism for a private enterprise. And since I have just a little bit of time, and maybe I can finish early here, I want to go back to this, what the taxpayer said about nexus. They are throughout, they usually, I think I heard Bella, and I'm assuming the taxpayer is referring to Bella Hess, and that body of case law applies to sales and use taxes. I don't think it's ever been applied in a property tax because in a property tax, it's the property that gets taxed. And if the property's here, then these in personam contacts aren't terribly relevant any more than an individual that owns a Kansas farm and enjoys income from that farm. Farm's here, subject to a property tax. Taxpayer may get nothing but a check deposited in his or her bank account. So I think it's very important. Maybe you look, and I'm sure you will, at the Oklahoma decision.
That all seems to make a lot of sense when we're talking about the typical property that I can point to and say, that's my chair, or that's my farm, that's my whatever. But I think the thing that makes this mind-bending is that we're talking about that fiction of not knowing whose gas is actually the gas in the pipeline. And so having to reach out to allocate that to owners, then does that bring in the need to have those in personam contacts or reasons to say that there is sufficient contact or sufficient reason to know that we can tax you in Kansas?
Yes, I think so, because, as I said earlier, they own some fraction of every single molecule. They choose to assign the gas that they purchase to storage facilities with the knowledge of foresight that it's going to be commingled. And we do have the UCC in this state, and I think it's 847-208, subpart B perhaps, which talks about fungible goods. And so they own every single molecule. It's commingled. They don't say to the storage company, keep my gas in Iowa, which the storage company couldn't do anyway. And they have no control over where the gas gets redelivered from. It's commingled product. It's like wheat in an elevator.
Counselor, I understand that argument about each molecule, and I was trying to relate it to the storage of wheat, since we're in Kansas. And I finally came to the conclusion the major difference is, even though my wheat is commingled with a lot of other people's, and I'm not going to get my wheat back, I did deliver it to a Kansas elevator. And so I made the step or availed myself of the state of Kansas. But if my particular elevator happened to rent property a couple of miles south into Oklahoma and move part of the grain there for part of the year, why have I availed myself of Oklahoma? You follow what I'm
Yes,
saying?
I hear
If
what
they
you're
delivered this gas to a storage field in Kansas, I'm with you. But they delivered it outside the state, and they have no control over where their contractual party on the other side stores it.
If you accept, as I believe you do, Justice Johnson, my proposition that they own a fraction of each molecule, and that molecule that they own a fraction of is physically in this state on January 1, and that's what we tax, and it's a property tax, I think that's a little different than some wheat down in Oklahoma, which we don't tax. We don't tax natural gas in Oklahoma either, or in Iowa, or wherever. We just tax what's
He's
here.
putting Oklahoma in the position of Kansas, I think, with his question.
Right.
I'm sorry.
Go ahead.
Say I delivered it in Oklahoma and they had a facility in Kansas. Let's flip it to make it comparable. Why would I have to, as an Oklahoman, why would I have to pay Kansas tax when I delivered it to an elevator in Oklahoma? And I'm fine if they keep it, and I don't care where they keep it, because if I'm going to physically take it back out, I'm going to go to that elevator in Oklahoma and take it back out. And in the interim, wherever they may take it and store it is of no consequence to me.
Perhaps not, but the fact of the matter is, from your hypothetical, the wheat you stored is in Kansas on tax day.
That doesn't answer Justice Johnson's question, though, which is just because they own, as you say, a fraction of every molecule of the gas, that doesn't mean that they've purposely availed themselves of the Kansas pipeline. Can you
Yes,
answer that question? And can
I'll
you
try
cite
to.
us any authority that would indicate that type of less than affirmative action can constitute availing themselves? That makes sense. Purposefully. The word purposefully is what's important.
Yes. I go back to what I said previously, is that case law about personal availing oneself has to do with sales and use taxes. To my knowledge, no court of last resort has ever attempted to apply that kind of a test to a property tax. And I do have a series of cases from federal courts, New Jersey and some other states, that very directly limited the applicability of the Bella Hess and the Quill case to sales and use taxes. And so when we talk about this purposefully availing oneself, we're really talking about somebody selling products through a mail order catalog, something of that nature. It's a sales and use tax. And I know I'm getting a little repetitious here, but it's a property tax on property that's physically here. And I think it would be a mistake to try to take case law that I don't believe any court of last resort has ever tried to apply in a property tax context and do it here in Kansas.
The bottom line is you say that no purposeful availment is necessary when you're talking about property tax. That's the answer to the question.
It just doesn't
That
apply.
that would be correct, but I don't know that I've completely conceded that there isn't some purposeful availment here.
You've got a
There
plan
aren't very
B.
many storage companies. You got a choice of 4, essentially. Well, there may be more.
You have a plan B.
And
about what
you
they
sign
can
a
notice of.
tariff, and that tariff identifies where their facilities are. You've contracted in a little more of a strenuous manner than delivering a load of wheat to the elevator, I believe.
The pipeline company signs the tariff, or their
I
customers.
asked one of the taxpayers experts, and I'm sorry, but I forget which one, whether the customers were subject to the tariffs, and he said they were. And that can be found in the record, I'm confident.
Counsel, I see you're out of time. Would you like 30 seconds to summarize?
Yes, Your Honor. You got essentially 2 roads that you can go. You can strike down House substitute for Senate Bill 98, find it unconstitutional, or you can uphold its constitutionality. And to uphold it, you're entitled to a lot of presumptions. You're entitled to the presumption that the legislature intended to enact valid law. You're entitled to the presumption that if there's any reasonable way to construe a constitutional term as a statute is constitutional, you're to do so. You are entitled to not try to put a fine edge on constitutional terms and interpret them in some highly technical manner. If you are to use the person of common understanding definition when it comes to defining constitutional terms such as public utility. Thank you very much.
Do we have any further questions of council? See none. Thank you.
Thank you.
Reserve 3 minutes for rebuttal.
May it please the court. Mr. Waters indicated that what the state of Kansas is doing is allocating ownership. And that is where the problem lies. You cannot allocate ownership and constitutionally comply with the nexus requirements of the due process and the Commerce Clause. This nexus requirement is not new. It's in the complete auto test, and it is something, frankly, that courts have been struggling with since the country was founded. We believe that the importance of nexus is highlighted by cases such as Bell Hess, which represents a key part in that nexus. What is the required nexus? Well, Bell Hess says it's more than simply dealing with the common carrier. This nexus requirement is also informed by the other older cases, such as the moving in interstate commerce case. Are you present enough to be taxed if you have goods that are in transit through a state? And those cases say you do not have sufficient nexus. All of these cases deal with this central idea. And if you're only allocating ownership, if you're not relying on the presence of any activity or the presence of the defendant or any activity directed to the state, then you violate that nexus case. In this regard, we must distinguish the MGE case from Oklahoma. In that case, there was a finding by the court, and that finding was that the gas in that case originated from originated from Oklahoma and was placed in storage in Oklahoma. That was held to be sufficient nexus. The people in that case purchased the gas in Oklahoma, stored it in Oklahoma. Court said that is fine. Compare that with the case that the Texas court considered in Peoples Gas, Light, and Coke Company. The Peoples Court, and yes, I am citing the People's Court as authority, held that without that kind of a fact, and that fact was absent in that case, the court held there is not enough nexus. You are not there present enough to be taxed. We think that that is the problem here. We also believe that there are problems when you treat the citizens of Kansas municipalities different than the citizens of out-of-state municipalities. We don't believe that the 1911 Holcomb case can withstand current scrutiny under the current statutes. For all these reasons, we believe that the Court of Tax Appeals must be overturned, and this court should apply its holding in the Central Illinois case and find that these taxpayers are constitutionally entitled to the Merchants and Manufacturers Inventory exemption. Thank you.
Do we have any questions of counsel? I see none. Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement.